Well, good morning, everyone. Welcome to Guildhall Chambers Spring Financial Services webinar series. John and Jay spoke last week on some interesting recent developments in relation to financial services protection in relation to SIP provision. And today we're going to focus on lenders' duties and liabilities following a decision of the Court of Appeal in a case called Morley and Royal Bank of Scotland. Before I start the talk proper, a few reminders to mute your microphone, switch off your camera. Please avoid taking control of the PowerPoint slides. And if you're interested in asking questions, please do pose a question on the chat function and we'll hopefully pick those up at the end of the webinar. So lender liability after Morley and the Royal Bank of Scotland. Both John and I were instructed at first instance and in the Court of Appeal in this case, and it involved allegations in relation to the conduct of Royal Bank of Scotland in the heady days of 2008, 2009, 2010, where, of course, the position of the banks was under considerable stress and strain, and there was some extreme conduct on their part. So far as Mr. Morley was concerned, he fell into the unfortunate category of being one of those borrowers who was in the commercial and industrial property market and was identified as being someone who potentially the bank concluded it wanted to exit the relationship. There was a lot more to the backstory than that, but ultimately his relationship was transferred into GRG, and then followed various negotiations, and ultimately Mr. Morley passing over, agreeing consensually, in inverted commas, to pass over 2/3 of his property portfolio to West Register, the subsidiary of the Royal Bank of Scotland. So that formed a nutshell backdrop to the trial. Mr. Morley brought proceedings at first instance, and Mr. Justice Carr found that a threat had been made in the context of the negotiations, but ultimately concluded that threat was unlawful and rejected Mr. Morley's claims that there'd been a breach of duties of skill and care and of good faith. The matter went up to the Court of Appeal, and in a judgment of Lord Justice Mayles, in respect of which the remainder of the Court of Appeal concurred, the Court of Appeal concluded that the appeal should be dismissed on the principal grounds that the findings of fact made against Mr. Morley in relation to the tort of intimidation and duress were such that even if a breach could be established, Mr. Morley could not get past that hurdle. And they also, contrary to the first instance decision, tightened up the view as to whether or not a relevant duty could be said to be operable in any event after an event of default. And it's in particular in relation to that area and the question of what duties are owed in the context of duties of good faith, and in particular to act solely having regard to the legitimate commercial interests of the lender, that may yet go further. A permission to appeal to the Supreme Court has been lodged, and a decision is awaited. So with that outline of the litigation, I'll briefly set out the headings we're going to cover in the talk today. John is going to start off by looking at the scope of regulation in relation to secured lending to set the scene for the common law approach taken in Morley and Bank of Scotland. He's then going to outline the facts in a bit more detail in relation to the case. And then I'm going to analyse a little bit more the underlying causes of action and the reasons why those were rejected at first instance and by the Court of Appeal. And John is then going to look a little bit more at the interaction in relation to this case and other cases vis-a-vis the lender's duties as mortgagee, because of course there are two capacities which need to be considered where there's secured lending, both from the perspective of the lender in advance of default and enforcement, and in relation to their powers as mortgagee and enforcement. And then we're going to offer up a few concluding remarks, and you'll have an opportunity to ask some questions. So John, I think it's over to you.
Thank you Thank you very much, Hugh, and good morning, everyone. We thought it might be helpful just to set the scene to provide a thumbnail sketch of the current regulatory landscape in this area. Much of this material, I'm sure, will be extremely familiar to most, if not all, so it can be taken quite shortly. Historically, commercial and residential lending, of course, has been unregulated in the United Kingdom, and if there was to be any issue raised about the suitability of a lending proposal or package that had been put forward by a lender, then the only way of establishing liability really was to demonstrate that the lender had assumed some duty of care of an advisory nature towards the borrower. That set the evidential bar very high, although one notable, well-known example is, of course, the case of Verity and Lloyds Bank, where a duty was able to be established on the facts. It was in that perhaps unsatisfactory state that from the 31st of October 2004, regulated mortgage contracts were taken into regulatory control. Those, as I'm sure most if not all will recall and be familiar with, regulate loans to individuals which are secured over land in the EEA, where at least 40% is intended to be used as a dwelling, and that by the borrower or a person an individual connected with the borrower. That's a definition in Article 61 of the Regulated Activities Order. And so to that extent, it can be seen that the law at a regulatory level is beginning to extend a measure of protection for at least mixed residential commercial loans. The type of protection bites at a number of levels. First, in an advisory context in relation to product selection, and then secondly, and perhaps more particularly relevant by analogy to Mr. Morley's case, in terms of the exercise of lender enforcement powers. As regards product selection and enforcement powers, both of those levels of protection are provided by rules set out in that part of the FCA handbook known as MCOB, and just focusing on two particular ones, MCOB 4.7.2, a rule imposing an obligation on a person advising on or recommending a regulated mortgage contract to ensure that it is suitable for the borrower. And suitability in that context has three components: that it must be affordable, it must be appropriate to the needs and circumstances of the customer, and must be the most suitable product to which that particular advisor has access. As regards enforcement powers, MCOB 13.3.4 obliges a mortgagee to give consideration to a number of factors, some of which I've underlined on that slide, but they include steps such as, for example, extending the mortgage term where there's been default, or deferring payments of interest, or capitalising in certain circumstances the interest shortfall. So there's a statutory recognition there that the lender's rights, as it were, at enforcement may, even in a mixed commercial residential context, require a degree of control. Those measures were, of course, of no protective avail to Mr. Morley. And just to go into the facts in a little more detail, following Hugh's thumbnail sketch, they concerned a commercial loan, a fixed 3-year term facility, granted first of all by RBS in December 2006 for some £75 million, secured over a property portfolio in the north of England. At the date of the advance, the portfolio had been valued at something approaching £95 million, so there was a fair degree of headroom in the facility already. One perhaps unusual feature of the advance was that it was on a no recourse to the borrower basis, so the bank agreed to limit its entitlement to recovery to the asset value that of the portfolio taken in charge. And there was a provision for, or requirement for, some 49 million of the lending to be hedged, and there was perhaps quite a generous margin of 1% over base. With the fall in interest rates, which you will recall, I'm sure, fell down to initially 1% in the early part of 2009, the bank realized it was losing money on this particular piece of lending and began to put some pressure on Mr. Morley to rebase the loan to LIBOR away from Bank of England base rate, and was also pressing him to hedge the entire £75 million facility. Mr. Morley resisted those initiatives and faced with that in January 2009, so nearly a year before the facility was due to expire, the bank obtained a desktop revaluation which downvalued the portfolio now to £59 million. Now that obviously had an impact on the loan to value covenant and arguably placed Mr. Morley in breach. In July of 2009, so 6 months before expiry of the facility, the connection was transferred into the infamous GRG unit of the bank. And two particular aspects of this arrangement to note are that first, the loan was being serviced, and secondly, it was recognised by everyone, Mr. Morley and the bank included, that asset values would, in due course, be expected to improve and recover. So come December 2009, the loan reached formal expiry date. In the lead up to that period, the bank had been proposing certain refinance terms to Mr. Morley, targeted in part at seeking to undo the non-recourse nature of the facility. Those were regarded as being uncommercial and stacked unfairly in favour of RBS as lender. And the negotiations then turned, those initiatives having failed, to Mr. Morley buying back the portfolio. Now, on one view, of course, given the non-recourse nature of the facility, it might be thought that any offer in excess of the then downvalued market value of £59 million would represent the maximum level of recovery that the bank could achieve. The buyback initiative was not frustrated, but compromised to a degree by the intervention at this point of the Asset Protection Agency, you'll recall, which was a government quango designed to provide some form of insurance underpin to participating banks, of which RBS was one, in relation to defaulting loans. And it was in the interest of the APA, because the insurance cover would not bite if the property portfolio was simply transferred to the bank's subsidiary, West Register. Negotiations culminated in July 2010, so 6 months after expiry, in the threat to which Hugh alluded, that if Mr. Morley would not consensually transfer the entire portfolio into RBS's West Register, the bank would simply appoint LPA receivers and effect the same transfer. Mr. Morley was partially successful in resisting that threat by agreeing to surrender 2/3, 3/4 of the portfolio to, I say RBS/West Register, on the basis that, as the judge accepted and found at first instance, there was no discernible difference between the subsidiary and the bank. Having agreed, inverted commas, consensually to transfer that proportion of the portfolio, Mr. Morley was then agreed a figure to buy back some 25% of it. But in losing the lion's share of the portfolio, of course, he lost the income stream, which was recognised as particularly valuable and was the means by which the facility was being serviced, and also lost the chance of capital appreciation. That perhaps slightly more detailed summary of facts begins to sound a little bit like a finals law examination question, and which would then lead to what claims does that history suggest might be available to Mr. Morley. And to answer that part of the presentation, I pass back to Hugh.
Well, thanks very much, John. Faced with that challenge, how do we construct causes of action? In relation to the three basic claims which were raised in this case, The first cause of action, which was focused on, was the tort of intimidation, looking at the coercive impact of the threats made by Royal Bank of Scotland on Mr. Morley's position and compelling him to enter into what was referred to as a split deal, whereby the majority of the portfolio was handed back to the bank, or more precisely, its subsidiary West Register. Secondly, to the extent that it may be said that the threats were not unlawful or illegitimate, whether or not there may be grounds to attack the transactions on the basis of economic duress, and in particular, whether or not, in order to succeed in that respect, it needed to be showed that Mr. Morley was still entitled to rescind, or whether it might also be argued that, in fact, the tort of intimidation is now more or less coterminous with the tort of economic duress, and may provide a tortious cause of action irrespective of any arguments about rescission. The third area, which was focused on, was focusing very much on the suggestion by the bank itself, and in particular Derek Sage, to the effect that the service provided by GRG was intended as a service to the borrower, and that the assessment exercise carried out in GRG in order to assess whether or not the borrower's buyer was carried out in a manner which was the bank would have it in accordance with good business practice in relation to restructuring and assisting borrowers, and was therefore using that aspect of the bank's own professed servicing of the borrower and assistance to the borrower to say that the bank in fact had not carried out that work, that assessment and that work with reasonable skill and care, and moreover, when making proposals to the borrower consequential on that, even though the borrower was in default, the bank nevertheless owed a duty in relation to that aspect. The second limb of the duty of care was to look at duties of good faith, and this can be viewed in two ways. One is on the basis that there is a positive duty of good faith, and as some of you will be aware, some people have tried to advance such an argument on the basis of that the lending contract being a relational contract, that so far not found particular favour in relation to high street bank lending relationship claims. A second limb of attack has been to use what's referred to as SOSIMA type implied terms, and that gained more traction in the Court of Appeal in the Property Alliance Group in a sort of pared back way by reference to considering what was in the legitimate commercial interests of the lender. So those were the field, if you like, of causes of action which were advanced at first instance and in the Court of Appeal. And what we're going to do now is to look in a bit more detail at each of those causes of action and how they were addressed by the first instance court and the Court of Appeal. So starting first with the question of tort of intimidation, the leading case is still the case of Rooks and Barnard going back some 70 years or so, or perhaps slightly less, but a considerable period of time. And the following key ingredients are identified. Firstly, a threat by the defendant to do something independently unlawful. Secondly, the threat must be intended to coerce the claimant to take or refrain from taking some course of action. Thirdly, the threat must in fact coerce the claimant to take such action. And fourthly, loss or damage must be incurred as a result. There is a live question in relation to this as to the boundary of the claim and whether or not doing something independently unlawful means unlawful as recognised under the law, or may be said to encompass a wider concept of illegitimate activity. That was assumed as being potentially arguable by reference to some of the reasoning, by reference to, for example, cases involving blackmail, which might be viewed as illegitimate, but perhaps not otherwise independently unlawful. There's an argument to the contrary in that respect. So the key focus here for the purposes of this was a threat made, was it unlawful, and did it coerce Mr. Morley into entering into the split deal which took place? And the way that was disposed of at first instance by Mr. Justice Carr was First of all, he found that a threat had been made, and the threat was that the bank would appoint receivers to sell the portfolio on a pre-pack basis to West Register. He was satisfied from the tone and demeanour of the bank employee that this was a threat made at a meeting in July to Mr. Morley's advisors and was intended to be coercive. However, he concluded on the unusual facts of the case, notwithstanding the fact that what was being threatened was more akin to a seizure than a sale, a seizure by West Register. But nevertheless, because of the fact that this was an unusual scenario, whereas a non-recourse loan, where in relation to the actual value of the asset, it was underwater, he questioned whether or not if Mr. Morley had made an application for an injunction, the bank might nevertheless have turned around and said, well, do you know what, we're willing for West Register to sort of sell it on the open market basis to save themselves, and or perhaps more substantively pointed out that it might be said Mr. Morley did not have an interest in the equity of redemption because the loan was underwater. He then went on to conclude, when dealing with questions of duress and tort of intimidation, that in any event he wasn't satisfied that Mr. Morley had in fact been induced to enter into this agreement because of the threats. He said that in fact Mr. Morley had resisted the threat. So that was the basis upon which that went up to the Court of Appeal, and the Court of Appeal observed that all sorts of interesting arguments have been raised in relation to whether or not the threat was lawful or unlawful, but ultimately concluded they didn't need to concern themselves with that, because they concluded that the finding of fact at first instance in relation to Mr. Morley not being coerced was fatal to Mr. Morley's case. Mr. Morley sought to run the argument that in relation to questions of threats and duress, that you don't necessarily need to be coerced into the precise act which is threatened, and use the example that if someone was saying to me, I'm going to hit you over the head unless you give me £5, and in response to that threat you only give them £3, is it really right that in those circumstances there isn't a cause of action known to law? Nevertheless, the Court of Appeal went further than perhaps arguably the first instance judge did in rationalising the approach taken by the judge at first instance, and concluded that actually, standing back and looking at it, this should be viewed as a split deal which Mr. Morley was pressing for as much as the bank, and therefore in effect there was no coercive effect as a result of the threats on the basis of their reading of the first instance judgment. So ultimately the interesting questions in relation to lawfulness versus unlawfulness were not addressed by them. John, I think, is going to come back to look at that in a bit more detail, because of course in this context what is being considered is a threat to do a future act as mortgagee. That's the necessary component of the threat which we're looking at. But as I said, John will come back and look at that in a bit more detail in a moment. But let's move on to the other parts of the case and see how those were dealt with. So on the question of tort of economic duress, the law obviously distinguishes in this context arguably between lawful and unlawful act duress. And it's well established that there is a certain category of case where the act in question which is threatened, or the pressure, is viewed as being lawful, but nevertheless is illegitimate in a sense, so that it's a threat to do something that is morally and socially unacceptable. And so the question here was, even if the threat to do the act was the threat to do something unlawful, nevertheless, could it qualify for unlawful act duress on the basis that of some sort of improper purpose in relation to looking at both the question of the demand and the threat. And it was said by Mr. Morley that the judge had in fact confused what was required in relation to the demand and the threat, so far as good or bad faith was concerned. Ultimately, that particular argument didn't go any further because of the way that the court dealt with the question of causation. But it should be noted that the bank conceded on appeal that the judge probably had got the question mixed up as regards the focus on the demand and the threat. I won't say any more about that because I anticipate we're likely to get a reasonably comprehensive review of the law in relation to this by the Supreme Court in a case called Times Travel. That case rested at the Court of Appeal when we were in the Court of Appeal in Morley in the Royal Bank of Scotland, and had been heard by the Supreme Court, but the Supreme Court judgment is awaited. And it's anticipated that that will consider the proper ambit of economic duress, and in particular, the circumstances in which you can have unlawful act duress, and whether or not good or bad faith demands are required will be no doubt considered in much greater detail by the Supreme Court in that case. So I won't go into that area in much more detail on this talk, unless there's anything, John, you wanted to say. So in relation to the next area, I should just say one further point, that an argument was raised because it mattered as to whether or not there was a remedy available at the end of all this, as to whether or not economic duress could constitute a tort or not. And if not a tort, then whether or not the remedy of rescission is lost, or whether you can get damages in lieu if you've in fact lost the right to rescind. The Court of Appeal put that into the basket of interesting legal arguments not required to be determined in this case. But you should just simply note, by reference to the cases we mentioned there, that that is potentially still a live point, and it may well be the Supreme Court says something about that in Times Travel. So ultimately, on economic duress, the matter didn't proceed much further in the Court of Appeal because they pretty much dealt with it on the facts. It should be noted that some caution is required in relation to the first instance judgment to Mr. Justice Carr in that respect, it being common ground on the appeal that he had in places confused the requirements vis-a-vis the demand and the threat. So on to the third category then, in terms of breaches of implied terms, and starting first with the duty of skill and care. Of course, there are two bases upon which this can be advanced. One is under the statutory provision, under the Supply of Goods and Services Act, and the other is to the extent there's some sort of voluntary assumption of responsibility or tortious duty under the Headley-Byrne principle. As the lending contract was continued during the period whilst there were negotiations, even though there'd been a default, the duty, it was said by Mr. Morley, should be recognised as obliging the bank to exercise care and skill in relation to their activities during that period, including deciding whether and how to enforce. You can see that the court might want to tread carefully in this area, bearing in mind the fact that the ability to enforce in an unfettered way is viewed by the lending industry as an important part of their armoury. However, in the context of this case, the bank had gone on the record as indicating that its restructuring and viability assessments were viewed as being a service to the customer. It may be that might be viewed with some skepticism, but nevertheless, that was their publicly stated position. And they had their own internal manuals, which required their staff to carry out financial viability assessments and consider if default was caused by extraneous events, and if it was, to take that into account when assessing whether or not certain steps should be followed. Of course, reversing back to the key facts which John identified earlier on, the key facts here were that the borrowing was being serviced, and the only reason why there'd been an event of default was due to exceptional market conditions and the market fall loss. And that in itself, which of course then impeded the ability for Mr. Morley to raise capital other than as at market value prices. And of course, the way that the bank positioned itself meant that Mr. Morley was being pushed to seek to offer sums greatly in excess of that by reference to the bank's analysis of what it could achieve via West Register and a hold of the property portfolio assets via West Register for the medium to long term. So that provided the backdrop for the arguments in relation to this particular area. At first instance, the judge proceeded on the basis there was a duty of care, but ultimately concluded that there wasn't any breach of that duty in relation to any of the events. And key to the reasoning in this respect was a conclusion that Mr. Morley couldn't necessarily rely on, and certainly not solely rely on, the bank's own internal manuals and guides. The judge didn't go on to say what Mr. Morley could rely on, but ultimately concluded that there was no breach of this duty. And in a finding which was viewed as being relevant to both this and to the later arguments in relation to breach of duty of good faith, the judge concluded that the bank's actions were all rationally connected to its commercial interests. The Court of Appeal ultimately was more sceptical about there being a duty in this area, and the Court of Appeal's view was that in relation to this, they refused to accept necessarily a duty of care was owed in these terms. They say they accept that an implied term in the loan agreement, they don't accept that an implied term in the loan agreement has any part to play in the parties' relationship. Rather, their relationship was governed by the express terms of the mortgage and by the equitable principles applicable to that relationship. Now, part of the reasoning in this respect was based on the Court of Appeal's reasoning that the service here was provision of a loan, and after the loan had been drawn down, and save so far as there was further drawing from time to time, that service wasn't continuing. So they viewed the service as being quite restrictive in terms of the way they approached it. Mr. Morley's case was that there were ongoing services, and simply because the loan is a loan contract doesn't mean that the only services that the bank is providing is simply the drawdown of the money itself. But ultimately, the Court of Appeal adopted quite a restrictive view as to what services were being provided. And that's ultimately what led to the conclusion that they reached. That issue is potentially something which the Supreme Court may look at if permission to appeal is granted, because it seems that even though that the loan contract itself is primarily focused on provision of money, there are certainly certain further decisions and services provided through the ongoing provision of that loan, decisions as regards for how much longer that loan should be provided, and decisions in relation to the usual incidents and activities of a bank in relation to the lending, which is certainly seems to be ongoing. So there's a question mark arising as to whether or not the Court of Appeal drew that distinction too narrowly. But in any event, the secondary question arises, which is, even if there's no duty or breach of the duty to exercise reasonable skill and care, is there nevertheless a breach of a duty of good faith? Now, as I alerted you to all at the end of the litigation in the Property Alliance Group, there was a finding by the Court of Appeal that the lender had a relevant restriction on their powers following an event of default or an event in relation to loan to value provisions and procuring of valuations, that the exercise of that power was to be exercised in pursuit of legitimate commercial aims rather than, say, to vex the borrower maliciously, and not for a purpose unrelated to its legitimate commercial interests, or if doing so could not rationally be thought to advance them. So in Morley, the issue was as to whether or not in relation to this, RBS made decisions as buyer, having regard to its interests via West Register, instead of as seller. Sorry, not as seller, as lender. That issue was left unaddressed by the Court of Appeal in light of its conclusion that Mr. Morley had not succumbed. But let's just look at that reasoning in a bit more detail. So the breach of duty of good faith at first instance, Mr. Justice Carr didn't expressly address his mind the question of whether or not the bank, when it was acting as lender or acting as buyer in terms of its decision-making process. The Court of Appeal took the view that because the judge at first instance had made a finding that all the bank's activities were rationally connected to its interests, then therefore that was a finding which precluded further argument on this point so far as Mr. Morley was concerned. But interestingly, when the judge gave permission to appeal, he seemed to recognise that he probably hadn't addressed that expressly, and it was arguable, and he granted permission to appeal to the Court of Appeal for Mr. Morley to raise this argument, that the bank was acting as buyer via West Register rather than as lender. The Court of Appeal, however, took the view that at all times the bank was interested in securing repayment of its borrowing, and therefore that could be viewed as it was acting as lender at all material times. The unusual feature of this case, however, is that the bank was adopting a twin track approach. The twin track was, on the first hand, looking at whether or not it could procure as much money from Mr. Morley to buy back the portfolio, or a discounted redemption as it was referred to. The second one was simply to enforce via a receivership, as we know in this case, a West Register receivership. And Mr. Morley's central complaint so far as the acts of the bank were concerned was, on the first limb of the track, the bank was always looking at a sum which was measured by reference to what it could achieve under the second twin of the track. In other words, a West Register purchase. And so in those circumstances, there was never an ordinary open market argument, if you like, as to whether or not Mr. Morley was offering market value for these assets when considering the discounted redemption approach. And the bank was always calibrating its decision making by reference to its interests as the holder of West Register and the ability to hold these assets for their gain. And the fundamental question which we think arises in this case is, when a borrower enters into a lending contract right at the outset with the bank, do they really contemplate that at the end of that process, if there's been an unlucky fall in prices, that they're being put into a competitive position with the bank vis-a-vis those assets, and that rather than simply looking at the value of those assets as they stand at that time, the bank can turn around and say, do you know what, we're interested in buying these assets for ourselves and taking these assets in-house. To us, that seemed to us to be contrary to what you would ordinarily view as being the legitimate commercial interests of a lender. And it's inherent as part of the lending contract that both the borrower and the lender view themselves as having aligned interests. And a conflict of interest seems to arise as soon as you contemplate the lender being able to have an interest as buyer on the other side of the fence. However, the Court of Appeal disagreed, and that is another issue which potentially, if the Supreme Court give permission, will be considered in due course by the Supreme Court. So, John, I think it's probably now over to you to look at the final area, looking at lenders' duties as mortgagee and the sale to self.
Thank you very much, Hugh. Yes, as Hugh mentioned, the judge at first instance, Mr. Justice Carr, was minded to accept that the threatened disposal to RBS's subsidiary would, in most circumstances, be regarded as a threat of an unlawful act, and that was a function of the standard jurisprudence around the exercise of mortgagee powers. In this context, the reason that he concluded that he couldn't be sure or sufficiently satisfied that it would be unlawful was because of the question as to whether Mr. Morley had any real interest in any equity of redemption, given that the value of the property was by then significantly underwater. there the position sits as it were at first instance. Given the Court of Appeal's emphasis, however, on the idea that once there's been a default, then everything goes out of the window, save for the mortgagee's duties as a fiduciary, it's perhaps helpful and instructive just to have a look more closely at what those duties entail, and that's the purpose of this next section of the talk. It is absolutely obvious standard trite law that a mortgagee cannot buy the mortgaged asset itself. And there are two reasons for that. The first is just a technical reason that a person cannot contract with themselves. You need two parties to achieve a contract. And secondly, the principle is informed by the recognition that there is an inherent conflict of interest in a mortgagee seeking to fix a fair price. Those principles, or that rule, emerge from quite an old case now, Farrer and Farrers, going back to the tail end of the 19th century. What is and has been supposedly applied more recently in, say, Quang Lam. What exercises us, I think, and is ripe, we think, for consideration by a higher court, is quite how far those principles go and whether they've been accurately articulated as a result of those two decisions. In particular, going back to Farrer, that concerned a mortgage over some quarry land, which, in relation to which the borrowers had defaulted. An agreement had been reached, the date of which was in fact in about November, December 1885, whereby the mortgagor or mortgagees agreed that one way out of the difficulty would be if a new company could be formed to take on or to buy the charged quarries, and there had been agreement that as long as a newly formed company was willing to pay then, no doubt, the significant sum of £7,700, that would be an unobjectionable event. That agreement having been made, a company was then formed and a transaction of sale proceeded at that price. As it happened, well after the agreement had been reached, one of the mortgagees, a Mr. Farrer, who happened to be the solicitor setting up the company, took a shareholding interest in the newly formed company. And there was then a challenge to the integrity of that transaction, raising an issue as to whether or not it was legitimate for the company to have concluded the purchase, given that one of the mortgagees had an interest in that company. And when one looks carefully and closely at what the court said or decided in that case, they emphasize a number of key facts. First of all, that the terms were not, it was found, in any degree affected by the circumstance that Mr. Riley, and importantly now, subsequently agreed to become a member of the company. The finding was that Mr. Farrer had agreed the original deal, and at that time he had no conflicting interest in the matter. And the conclusion on appeal was that the sale could not have stood if, when the agreement for sale was made, Mr. Farrer had been indirectly one of the borrowers. His subsequent conduct did not invalidate the sale then agreed to, and which was afterwards carried out. And the court said Mr. Farrer was not a trustee selling to himself, nor was he buying indirectly for himself. Now, it can be seen that all of that turns very carefully on the relevant sequence of events. And it seems to us that it is well arguable that it doesn't support a bold proposition that a sale by a mortgagee to a connected party, whilst overcoming the first legal difficulty of not having two separate entities to that transaction, that it doesn't necessarily follow that the transaction should not be caught by the rule that a mortgagee simply cannot buy a property from or sell a property to a connected entity. The court allowed the transaction in that case to stand because of the overwhelming evidence that it was not tainted by any form of impropriety. What that doesn't really address, however, is the situation that where the subsidiary company is wholly owned and the directors of both entities, mortgagee and subsidiary, are identical, as wasn't the case in the transaction between RBS and West Register, why that transaction ought not to be caught by the basic principle that it is no-go territory for a mortgagee to sell to an entity in which it has an interest. Nonetheless, that the law has developed in a way which has accepted that it is not inherently objectionable for a mortgagee to sell to a company in which it has an interest, and that was further enforced and upheld in the Tsay Kwong Lam decision. Again, however, when one looks carefully at the reasoning in that case, it starts from an acceptance by counsel for the mortgagor that there is no blanket ban on a transaction between a mortgagee and a connected subsidiary. So the position proceeded in that case simply on the basis of counsel's acceptance that that was the law, and the essential authority for that proposition was given or cited again as the case of Farrer and Farrers. And I've just indicated why, when on careful reading, that case may not support the proposition to quite the extent as suggested. I skipped over those slides, but you can look at them in more detail. The next issue which arises is this: that it is and was submitted by RBS that it was irrelevant whether RBS may have had some ulterior motive in pushing through this transaction of sale or disposal to West Register, namely to profit itself from the income stream or to benefit from any subsequent enhancement in value, because on any view it could be said that part of the strategy was designed to secure repayment of its loan facility, and reliance was placed on the decision in Cookerova Finance in 2016 that so long as a reason for a mortgagee enforcing its security is to obtain repayment, then it is said it doesn't matter that it might have some ulterior motive. Now, again, that proposition seems to us, certainly at an appellate level, open to fresh and further consideration. Again, the basis for it in Cookerova, when one looks carefully at the facts of that decision, do not, we suggest, support a proposition in such bold and bland terms. The background to that case concerned a Russian conglomerate who had advanced, which had advanced a loan to a Turkish cell phone company. And as part of the security, a charge was taken over shares in a subsidiary of the borrower. The agreement contained an express provision that in the event of default, the Russian lender could simply appropriate the shares of the subsidiary entity, and there were also some relevant legal regulations governing this type of transaction, which provided for exactly the same form of remedy by way of appropriation. There was a default. In the events which happened, the Russian company seized the shares of the subsidiary with the very obvious motive and intention of acquiring the cell phone company itself. It wasn't particularly concerned about the recovery of the outstanding loan. The principal issue was that the principal motivation was simply to acquire the shareholding. The court said that in those circumstances, given that the very thing the contract and the regulations permitted, it was impossible to contend the lender was exercising a power for a collateral purpose, and went on to say that that was quite sufficient to dispose of the case. The court then went on, nonetheless, to volunteer more generally the proposition the board considers that if the chargee enforces his security for the proper purpose of satisfying the debt, the mere fact he may have additional purposes which are collateral to that objective cannot vitiate the enforcement of the security. Now, one can see immediately, therefore, that the basis of this so-called blanket ban or blanket entitlement to take action for whatever ulterior reason, as long as part of the thinking is desire to recover an outstanding loan, that it rests on pretty shaky jurisprudential footing. The other issue which arises is that there is now, it seems, an emerging difference of approach when the court is looking at the validity of an exercise of a power pursuant to a contract to achieve a particular result. The decision in Eclair's group concerned a claim by claimants in relation to certain actions taken by the board of a defendant company. The claimants were beneficial shareholders in the defendant company, and there was a concern by the board of that company that those standing behind the shareholders may be pursuing some form of hostile takeover. In those circumstances, the board issued an information request under Section 793 of the Companies Act to the shareholders to provide information about their shareholding. The answers and the information which came back were considered by the board to be materially inaccurate and false, and that prompted the board to exercise a power in Article 42 of the Articles of the Company to impose a restraint on the extent to which the claimant shareholders could participate in a then upcoming annual general meeting. The result of that restraint was to prevent them voting at the meeting, and therefore to prevent them blocking or preventing any resolution being passed which required a special resolution majority. The claimants sought a declaration that the exercise of that power had been unlawful and was motivated by an ulterior motive, not to protect the company, but to prevent any external takeover initiative. The judge at first instance accepted that the power had been incorrectly exercised for that reason. The matter went off to the Court of Appeal, which determined more along Cucaroba style lines that there was a legitimate reason for the exercise of the power, and that was sufficient to save the exercise of the power itself from criticism. It then goes to the Supreme Court, where the court concluded that given that the dominant and obvious reason behind the exercise of the power was the ulterior motive, that was sufficient to vitiate the exercise of the power, and it had been invalidly exercised. Now, one can see a tension, therefore, between the law developing in that area of the exercise of contractual powers and the law surrounding, at the moment, the exercise of powers of a mortgagee. And it's clearly unsatisfactory that there should be different treatment in those two sectors. So those again are issues that may well feature in the event of permission being granted in Morley. But I pass back to Hugh now for any further concluding remarks. I think, Hugh, you're still muted.
Thank you, John. In relation to the case, therefore, I think you'll see it raises lots of interesting points of law which ultimately weren't finally addressed by the courts, and it may fall to other cases in due course to consider those points in more detail. If you want the references in the first instance judgment for caution needing to be applied in relation to the treatment of duress, it's paragraphs 236 and 237 of the first instance judgment. And in particular, just so you're aware, the reason why it was concluded that was wrong was that the judge wrongly concluded he should ask whether the threat was made in good or bad faith rather than the demand. And that was said to be inconsistent with what David Richards had to say in the Court of Appeal in Times Travel at 105 and 106. But ultimately, in relation to the Court of Appeal's approach, was a more restrictive approach on the law. It remains to be seen whether or not the Supreme Court consider that it's worthy to look at those points in further detail in due course. But even if they don't, there are still some issues bubbling away in relation to, in particular, connected party sales and the question of the extent to which those sales are either lawful or capable of being vitiated for the reasons John has identified in his concluding observations. It remains to be seen whether or not there's any further traction in relation to this area in relation to duties of care. I suppose the only other point to mention, John, is that there's been some discussion about the voluntary scheme set up by the banks fairly recently in relation to SMEs and their ability to try and make complaints in relation to their treatment. That's still relatively new, and it remains to be seen whether or not that provides satisfactory redress for small and medium-sized enterprises who are subject to enforcement action, which they consider to be inappropriate and unfair on them. So those are some of my concluding remarks. John, I don't know if there's anything further you wanted to add to that, or whether or not we should open it now onto the floor for a few questions. I see that one delegate has been amused to see that you think that Farah is getting quite old, John.
I wasn't sure whether that was a comment more on my own grey hair and the sense of a long reach back into history, but seeming not quite so long when you have grey hair. But I mean, it is an old case, and it's rests on a pretty shaky footing, I think.
I mean, some of those old cases, it has to be said, contain interesting discussion, don't they? And there's also an interesting discussion in the Australian case of Bangadilly, isn't there, which comes a bit later in the sequence of events, which also throws open an interesting spotlight on the extent to which it's a hard-edged rule or not in relation to sale to self or not, and where you draw the line in that respect. I mean, ultimately, the judge at first instance found that this was, if it had been other than a non-recourse lend, he would have found that it was a breach of or a threatened breach of those duties to contemplate a pre-pack sale to West Register. But on the facts, equivocated as to whether or not that could be said to be unlawful or not. And ultimately, the Court of Appeal found that in any event, his findings in relation to causation were such as to preclude any further argument by Mr. Morley on that point. So that remains another open debate, certainly at first instance level. Does anyone have any questions they want to pose? There's a chat function, a meeting chat function, where you're welcome to ask any questions if you want to, but it may well be you've got other things you want to crack on with now for the rest of your day. I should mention, whilst we're waiting to see if there are any questions, that this is the second of our Spring Financial Services webinar series, and there's another at least one or two coming up in the next few weeks, so keep an eye out for future webinar invites coming through on your email. We hope that you enjoyed today, and I was just about to wrap up, and we have got a question coming in. So I think the question has been asked, John, as to whether or not contingent liabilities of the hedging have any role to play. I think it's fair to say that the dispute in relation to hedging form more of the background rather than centre stage in relation to the Morley dispute. Some interesting features did emerge in the course of the evidence as regards hedging and contingent liabilities, and it appeared that the bank was using potentially fresh hedging pricing in order to recover via the back door, so to speak, certain costs which are associated with breaking a prior hedge. without fully disclosing that to the customer. So the history in Morley didn't do the bank any great favors in terms of its credit so far as it acted in relation to the hedging aspects of things, but it wasn't a cause of action as such, which was considered in that case due to the history of it, which probably don't need to bore you with. But John, I don't know if you want to say anything further on that particular point.
I think only this really. It was, in one sense, pretty disgraceful behaviour. The long and the short of it was that there was a quite a few £1 million break cost. I forget the exact figure. The bank, in offering a re-hedging, which ultimately wasn't taken up, but was seeking to induce Mr. Morley to accept a re-hedging proposal on the basis that it would, quotes, swallow half the cost of the break itself and lend to Mr. Morley the other half of the break cost. What became very clear from some behind-the-scenes email exchanges within the bank was that the pricing of the new replacement hedge was simply going to recoup through the back door the half write-off that the bank was otherwise purportedly offering at the front door. And then again, it's an indication perhaps of the need for more rigorous regulatory control over the way in which lending of this kind is carried on. But that's probably another unpopular view, I suspect, with lending institutions.
Well, it remains to be seen to what extent, I suppose, in relation to any enforcement activity following the pandemic, that hedging has quite the same feature. I suspect it may not, and people may have learnt their lesson to some degree in relation to those products. But one further question. Yeah, so the question raised by Emma is whether or not the bank acted or arguably acted in bad faith in relation to its attempts to get out of a bad commercial deal. And the short answer is yes, that was an allegation made at first instance. The judge at first instance concluded that the bank was legally entitled to use the loan to value ratio provisions to secure a revaluation. And if that meant a loan to value breach, then the bank was entitled to have negotiations with Mr. Morley in that respect. So the judge at first instance viewed that as all commercial fair game so far as Mr. Morley was concerned. You can see the argument certainly that might be said to be bad faith if ultimately the objective of the bank was to use that in order to procure the asset for itself. The judge took a more nuanced view as regards what the commercial activities of the bank itself were. John, I don't know if there's anything further you want to say to add to that.
I was just remembering there was a fairly juicy internal email, again, in which the bank was discussing having failed to persuade Mr. Morley to re-hedge and refinance on terms it preferred, i.e. reference to LIBOR, that they could, quotes, get him another way by, inverted commas, forcing a breach of covenant by having the property revalued. Well, the emails said what it said. I mean, in one sense, we're back into the territory, I think, of legitimacy or purity of purpose. There might have been, or there was potentially an argument that the property had lost value for a period. In the normal course of events, one might think lenders would, if the loan is being serviced, simply let events run their course. Rather than, to use the bank's own language, force a breach of covenant by finding a valuer who can return a down value and then rely on that as a breach of the loan to value covenant.
Yeah, I mean, it certainly was a relevant trigger for the purposes of this customer being pushed towards GRG. Though another relevant factor I suppose to take into account in terms of the timing, the history in relation to Mr. Morley was that, of course, the loan expired at the end of December 2009. So technically, irrespective of any LTV points there might have been, the bank was entitled under the terms of the lending contract to its money back at that date, whether or not there was a loan to value breach or not. So that was why, certainly on appeal, the focus was more on the events up to the split deal, or the consensual deal in inverted commas, which was concluded in the end of July, early August 2010. But it's a point. It's certainly a point to be alive to in relation to the activities of the bank moving forward, and depending on how effective any redress schemes that the banks are offering to put in place in the future. If it's considered there's been a bad faith act on the bank's part, then that's certainly something worth looking at in terms of its purposes and objectives. But for the reasons John has identified, be prepared for the argument, of course, that the bank will say, well, we're just simply acting as in our commercial interest as lender. So the short answer is permission to appeal has been sought from the Supreme Court. They normally take a few months to process their permission decisions. So anything in the next 3 to 6 months, potentially. Good. Well, I think we probably better wrap up there, John, because I'm sure everyone has got busy days to get on with. We hope you enjoyed the webinar today. Of course, John and I will be happy to share any thoughts offline separately with anyone in due course should they want to discuss matters. But otherwise, I hope you all have a good day, and thank you very much for attending today. Our slides will be circulated and sent out in the usual way, and this particular recording will be uploaded onto our website. So thank you very much. Good morning.
Good morning.